Now, in Loomis, the court concluded that the application of strict liability to online marketplaces can incentivize a marketplace like Amazon to expand its safety compliance requirements to more products and thus further the goal of product safety. In many cases, Amazon may also be the only member of the distribution chain reasonably available to the injured consumer to recover damages because the third party is overseas, quite often in China. The court also underlined that Amazon could pass the financial burden to the third party seller through its fees, indemnity requirements, and insurance by adding a sort of risk premium to the payment that the third party seller has to give to Amazon. More recently, the Texas Supreme Court held Amazon not to be liable, not to be a seller under Texas law with regard to products sold via the Amazon marketplace and that are delivered via its fulfillment center. So if you take all this together, and there are many more cases, the map of product liability for online marketplaces in the US is quite patchy. And this is not even the latest edition. It would have to be updated in order to cover the most recent cases. So it's a very patchy map. Now, the question that I'm asking in my paper is, how would a case like Loomis or Amazon or Bolger be decided in the European Union? The relevant EU law, of course, is the Product Liability Directive, which dates back to 1985, a time when there was no commercial internet and certainly no online marketplaces. Therefore, the liability system of the directive is based on the traditional supply chain model where the product reaches the consumer via a pipeline involving producers, importers, suppliers. Consequently, the directive imposes direct product liability primarily on producers and importers. Article 3 further extends liability to suppliers, but only where the producer or importer cannot be identified, so only a subsidiary liability. This model worked reasonably well in the 1980s, but it no longer reflects the reality of digital markets, which looks more like this or maybe like this. This structural change of online retail raises several questions. Can a marketplace like Amazon be considered an importer under the Product Liability Directive? Would the answer be different for fulfillment by Amazon and fulfillment by merchant cases like Bolger and Loomis? And finally, does the e-commerce directive or a future Digital Services Act shield Amazon from liability? Interestingly, there seems to be no prominently reported case law in Europe on these questions. There's an emerging debate among legal scholars. Here are two examples, but product liability litigation has not yet reached the European platform economy. Now, regarding the last question concerning immunity under the e-commerce directive, maybe the old Care Optica decision, this one, the Care Optica decision from 2010 could provide some guidance. In Care Optica, the Court of Justice held that the e-commerce directive and its safe harbor provisions only apply to the online part of a transaction, but not to the subsequent offline delivery of products. And this would be very much in line with the argument brought forward by Bolger, the Californian case, where the court held that Amazon's liability is not based on content posted on the Amazon website, online content, but rather on Amazon's offline role as being involved in the distribution of a defect product. So that would be a similar distinction between the online part and the offline part of the transaction. In other words, in Bolger, the court held that Amazon does not benefit from the liability privileges under Section 230 Communication Decency Act when it comes to product liability. Anyway, for the time being, there is a lot of legal uncertainty regarding the application of EU product liability rules to online marketplaces. But the EU legislator has moved forward in a different but related area, not product liability, but product safety. In June 2019, the market surveillance regulation was adopted, which has been applicable since July 2021, which requires sellers of CE marked products, for example, toys, electrical devices, to designate a point of contact inside the EU for market surveillance authorities. This so-called responsible person can be an importer, an authorized representative, or a fulfillment service provider. Now, interestingly, Amazon has turned this new regulation into a business opportunity, and it now offers what they call the Amazon Responsible Person service, but only for products that are delivered via Amazon's fulfillment services, and they charge 25 euros per month for being the responsible person. Now, the recent tightening of product safety regulations is complemented by voluntary measures, the so-called product safety pledge, a voluntary commitment of several major online marketplaces. The signatories, and here you see some examples of signatories, committed to take action against unsafe products that go beyond what is already required under EU law. There are conflicting views about the effectiveness of the product safety pledge. The Commission praises the progress made under the voluntary pledge. Consumer associations take a more skeptical view. So against this background, action in the field of product safety law, inaction with regard to product liability, there have been high expectations when the European Commission presented its proposal for a Digital Services Act in December 2020. And just a few weeks before, the European Parliament called on the European Commission to address the liability of online marketplaces, which have predominant influence over suppliers and where there is no manufacturer, importer, or distributor established in the EU that can be held liable. In other words, the European Parliament suggested to include a rule on product liability of online marketplaces in the Digital Services Act. The approach taken by the European Parliament seems to be quite similar to the recent case law from California. The criterion of predominant influence, in my view, seems to express the same idea as the criterion of control applied by Bolger and Loomis. However, the European Parliament suggestion did not make its way into the proposal of the Digital Services Act, which was published in December. The DSA proposal imposes a number of due diligence obligations on digital intermediaries and introduces a harmonized framework for enforcement, but the proposal is silent on the question whether online marketplaces can be held liable for facilitating the marketing of unsafe product. No positive rule on product liability of online marketplaces. So instead of suggesting new rules on product liability of online marketplaces, the European Commission seems to further focus on strengthening product safety rules. This becomes evident when you look at the proposal for the new General Product Safety Regulation, which was unveiled on June 30th this year. The proposal actually contains a new chapter on online marketplaces, and in particular, it requires online marketplace operators to consider certain product safety obligations. In particular, marketplace operators would be obliged to regularly check information in the EU Safety Gate database, like the example that you can see of the pressure cooker here, the apparently dangerous pressure cooker. Other obligations would include a duty to react swiftly to notices regarding product safety and to cooperate with market surveillance authorities in the case of product recalls. In other words, the new regulation would turn some key obligations of the voluntary product safety pledge into mandatory law. But again, no product liability rules for online marketplaces here. The situation could change again next year when the European Commission is expected to publish its proposal for the revision of the Product Liability Directive, which will then be 37 years old. A few weeks ago, the Commission already published its inception impact assessment, the very first step in the legislative process, which indicates in which direction the Commission is heading. This impact assessment, inception impact assessment, was published on the very same day like the General Product Safety Regulation, interestingly. The impact assessment, here is the cover page, acknowledges that the rise of online marketplaces could leave consumers with no liable person from whom they could seek compensation in the event of damage. In order to solve this problem, the European Commission suggests to extend the strict liability to online marketplaces, but only in cases where they fail to identify the producer. This would make it very easy, I think, for online marketplaces to escape product liability. They would just have to identify the third-party seller, even if the third-party seller is not reachable for the consumers. Consumers then would still be left without any compensation for damage if the third-party seller cannot be reached. Now, this very brief comparative overview shows that the regulatory strategies in Europe and the US differ considerably. While the US seems to focus on indirect regulation through product liability, the EU puts its emphasis on direct regulation through public enforcement of product safety rules and market surveillance by public authority, plus some flanking measures based on co-regulation, such as the voluntary product safety pledge initiated by the European Commission. Why? Why do we see these different patterns here? Well, possible explanations, and I delve a bit deeper into this in my paper, but possible explanations for this divergence might be found in the legal and political context in which product liability is embedded in Europe and the US. For example, the widespread availability of public health care in Europe might be one factor that reduces the need for victims to seek compensation of medical bills through litigation, through product liability litigation. Another aspect could be procedural law. Procedural law in the US makes it easier to file a personal injury claim. This is fairly inexpensive in the US. Attorneys typically take such cases on a contingency basis, which means that the financial risk for plaintiffs is much, much lower than in European countries. Finally, there may even be cultural factors. US cases like Bolger or Loomis could be seen as the tort law version of a broader techlash. that is currently shifting popular views against big tech. Just think of the Facebook files that are currently making headlines. In Europe, the societal debate about tech regulation seems to focus less on tort law, product liability law, but rather on the role of the state and public enforcement. But to be honest, the picture seems to be more complex, and it would be incomplete to ignore the small elements of public enforcement that are also visible in the US. Because most recently, there has been a move towards public enforcement of product safety rules also in the US. In July this year, the US Consumer Product Safety Commission, which was, let's say, understaffed and underfunded in the past, but that may change under the Biden administration. This CPSC filed a first of its kind administrative enforcement complaint against Amazon, demanding that Amazon take action over several dangerous products sold via the Amazon marketplace, such as inflammable children's sleepwear, carbon monoxide detectors that do not work, and dangerous hair dryers. The complaint, which was filed after months of negotiations between the CPSC and Amazon that failed eventually, commands Amazon to cease selling these dangerous products, notify consumer of possible risks, and make full refund available, and provide proof of such action to the CPSC. So maybe one scenario could be that we are moving towards some sort of transatlantic convergence of the regulatory models with a combination of public and private enforcement, however, with different degrees, you could say. If I have 5 more minutes, I would like to add an interesting side story or a subplot to the ongoing drama of platform liability. It's about a consumer law bill in California. Some courts in the US have argued that an expansion of product liability rules to online platforms is not a job for the courts, but rather a job for the legislator. This idea was taken up in 2020 by a California consumer bill, which suggested to introduce new legislation on product liability for online marketplaces. Now, as one would expect, this bill stirred a controversial debate. Unsurprisingly, a broad coalition of online marketplaces initially opposed this bill. This comes not as a surprise. However, the situation changed after the Bolger decision. This bill was introduced in February 2020. In August 2020, Bolger was handed down, the Bolger decision, and declared Amazon to be liable for third-party products. After the Bolger decision, in a surprise maneuver, Amazon issued a public statement indicating that it would support the California consumer bill, but only under certain conditions. Specifically, Amazon argued that the law should apply equally to all online stores, including all types of online marketplaces, or you could translate, including to Amazon's competitors, like eBay or Etsy. Following Amazon's change of strategy, the California Senate amended the bill and extended the bill to online interfaces, online platforms that only receive a fee for advertising a product. And this led to fierce opposition by platforms such as Etsy and eBay. They argued that the bill would severely hurt small online marketplaces and solo entrepreneurs that rely on such marketplaces to sell their products. In addition, they argued and one of the most vocal critics was the CEO of Etsy. Actually, they launched a campaign in California, and they argued that Amazon could even end up benefiting from this liability law, because Amazon would be better positioned than smaller competitors to weather the exposure to liability for defective products. Etsy called the bill a wolf in sheep's clothing and argued that it would actually help Amazon and crush smaller e-commerce players. In the end, the campaign against the California bill was successful, and the bill was shelved in summer 2020. But in February 2021, a revised version of the bill was introduced in the California State Assembly. But after the Loomis decision in April 21, this bill was also put on hold. This bill was also put on hold. So we still have to wait for legislation that could trigger a California effect, or that could become a model for other US states, or maybe even for the European legislator. Now, what are the lessons? And I finish on this note. What are the lessons to be learned from the failed attempt to legislate on product liability of online marketplaces? I think the criticism by eBay and Etsy may be somewhat exaggerated, but it does make an important point. The choice of the regulatory design for product liability rules does not only affect the relationship between the tortfeasor and the victim, but it also has implications for competition between different platforms. What type of control, and these are some, let's say, issues of regulatory design that we might discuss after my presentation. What type of control is necessary to justify product liability of online marketplaces? Is it necessary that the online marketplace exercises physical control over the product, as in Bolger, or is algorithmic control over the purchasing process sufficient, as in Loomis? The choice between these two alternatives may not only have consequences for consumer protection, but, as I mentioned, also for competition between online marketplaces with different business models. If product liability only applies to marketplaces which provide fulfillment services, this could shift the stream of unsafe products to marketplaces where products are shipped directly from the seller to consumers. And this could make it even more difficult to enforce product safety regulations for these products. Another possible scenario is that smaller marketplaces will shy away from offering fulfillment services in order to avoid exposure to product liability. This in turn would then, or could mean, that they offer consumers a poorer retail experience, as they will not be able to guarantee fast delivery, next day deliveries, seamless returns management, or reliable and standardized information about product characteristics and availability. In contrast, larger platforms would still be able to offer fulfillment services given their financial strength and considering their role as an unavoidable trading partner for third-party vendors. Platforms like Amazon would then still be able to charge higher fees from merchants and thus pass on the financial burden resulting from strict liability. So in the end, depending on the design of the regulatory regime, large platforms could actually benefit from extending product liability to online marketplaces. Now, does this mean that consumers should not be protected from dangerous products through strict liability? Probably not. The competitive effects of product liability described here are largely due to the fact that large platforms have become gatekeepers for third-party sellers who are seeking access to consumers in the EU and the US. But this, in my view, is a problem to be solved by antitrust law or ex-ante regulation, but not by limiting the scope of product liability rules. But that's probably something to be discussed. The paper contains some further ideas how a regulatory design for product liability might look like, but I stop here in order to leave sufficient time for discussion. Thank you very much. Here are some further readings, and I'm looking forward to our discussion.
Wonderful, thank you, dear Christoph, for this very inspiring presentation. We enjoyed it tremendously. And now I would like to open the floor for questions and comments by the audience. I'm sure this discussion will be very lively. Who would I would like to ask you to use the raise hand function. Do I see the raise hand function? Yeah. Yes. It's on the bottom below. Then reactions. You click on reactions, and then you find the raise hand function. All right. I see Mireia and LiaNs. Sorry for calling everybody by their first names, even if I don't know them personally, but you know, it's the online societal. Okay, LiaNs was the first I saw, then Mireia, and then Fernando Gomez. Welcome, Fernando. It's a great honor to have you with us. LiaNs, your floor is yours.
Thank you very much. Do you understand me? Do you hear me? Okay, thanks. Well, thank you very much for your interesting talk. It was great to hear about product liability from a comparative perspective. And for me, your talk really showed the struggle in which regulators, like how regulators struggle to deal with the phenomena of platform economy on both sides of the ocean. Really, and my question would be: you mentioned the cases, the US cases, which very much deal with the control, the exercise of control over the products. And my question would be whether the position of Amazon or other marketplaces is really so much different, or whether they have more control over the products than, let's say, any wholesaler in a normal supply chain, and whether there is really enough reason to address strict liability to marketplaces as Amazon, or if this is just like a way to find someone being liable apart from that. Thank you.
Thank you, Christoph.
Should I respond directly?
Yes, yes.
Yeah, I think if you look at the case law, and at the moment there are these two, let's say, diverging lines of case law, and there are still more pending cases. So the matter is far from being settled at the moment. It's still open. Of course, you could read this as a story of deep pockets liability. We are talking about, let's say, one of the financially strongest players in the online economy. But I think it's not just about deep pockets. I do think it's about incentivizing Amazon and to let's say provide liability incentives to use the leverage, to use the power, the influence that Amazon has over its suppliers. Amazon does not have control over the products in a traditional sense, physical control. Maybe even if you think of the products that go through Amazon fulfillment centers. I couldn't imagine Amazon to actually verify products that are shipped through these fulfillment centers. I think it's more about, let's say, liability, the threat of liability, also as a sort of, let's say, signaling device, where it adds a premium to riskier products. Apparently, batteries for laptops or for hoverboards or other electrical products are a common source of liability claims in the US. If that would mean that there's a let's say risk premium that third-party sellers would have to pay if they want to sell their products via Amazon, maybe the most dangerous products are simply priced out of the market because it's too the risk premium makes it too expensive for sellers of the very dangerous products. Maybe that could be a mechanism that is working here. So I think it's not just about deep pockets yeah.
Thank you very much, Christoph. And now it's my pleasure to pass the floor on to Professor Fernando Gomez Pomar. Fernando, the floor is yours.
Thanks, but I think Mireia was first in raising her hand. So Mireia, please go ahead.
Mireia explicitly allowed me to give the floor to you first because you have to leave.
Okay, thanks a lot. Thanks very much for the very insightful presentation. My question concerns whether really product liability is the area where we can really expect, let's say, more change in the legal status of online marketplaces. And perhaps some of the debates that are now taking place concerning product liability may not be transferred to contract law, in the sense that the Consumer Sales Directive allows member states explicitly to consider online platforms to be treated as sellers, even if they are never the owners or never assume any obligation to deliver the product. Well, perhaps through contract law, we may find, although it's true now that Directive doesn't really go into that and simply allows member states to do that, but I don't know, perhaps member states and courts within member states could expand the notion of seller, and by doing that, really make the online platform liable. Just to give you an example, and it does not affect online platforms, but I think it may provide a nice analogy. For instance, concerning Dieselgate cases litigated in Spain, the Spanish Supreme Court has considered as a seller, and therefore liable under general contract law, the car manufacturer, and not just the particular car dealer who sold the car to a given consumer. And basically the argument provided by the Spanish Supreme Court could be translated onto online platforms, which is, well, the manufacturer, given the way in which those products are distributed and reach the consumer, exercises significant influence on the process. And perhaps the reason could also be used for online, perhaps not all of them. And I see that your point is a fair one about different platforms having very different degrees of control about the contracting process. But in the end, my point is perhaps developments may take place under contract law and not under product liability law.
I perfectly agree. There is a parallel development in contract law going on. Just think of the European Law Institute's model rules for online platforms, where we try to actually borrow some ideas from US case law, the earlier Oberdorf decision from Pennsylvania, and translate it into contract law and use this idea of predominant influence or control to extend a contract law liability. And I think it would actually be quite a a common pattern that, let's say, deficiencies of tort law, of product liability law are dealt with in contract law. Think of pre-contractual liability in German law. A lot of doctrine regarding the extent of pre-contractual liability was built to fill gaps in tort law that are existing in tort law, or that could have been dealt with in tort law as well. One problem with contract law, of course, is that it would still require a contractual relationship between the victim and the platform. Some of the US cases concern third parties or fourth parties, you might say, where there is no contractual link to the platform. And there, maybe for such cases, some non-contractual liability would be required, I think.
Thank you very much, Christoph. And now Mireya's question.
Thank you very much. Thank you very much, first of all, for accepting the invitation and for the fantastic presentation. And I have two questions. The first one refers to the non-digital experience of product liability versus the US, the European and the US experience, and let's say, and let's say the impact, or at least the context in which product liability in the US developed with high insurance rates and in a way big litigation that we didn't see in Europe, probably due to the factors that you mentioned. Also probably because we have this ex ante product safety body, but also healthcare systems. So then one of my concerns is whether we would see something like that by being ultimately absorbed by public systems, the impact of that, because there would not be any surrogation by the public systems absorbing the cost of this harm toward, and then going filing any recourse claims against the platforms eventually. And I would like to see your thought about that. And the second question deals with the standard, the burden of proof. Like we always implicitly assume that a safe product is non-defective, or that a defective product is not safe. But this is really not true. The standards are different, the burden of proofs are different, and the ultimate goals of both regulations in terms of how to find a product unsafe and the determination of that is very different from how we do that with respect to an effective product. So, and in that respect, I also wonder how much enforcement is possible, even if we expand that. I was looking at the proposal, and the standard for safe product that I see is exactly the same one that we had in the regulation before. So there's no change in that respect. So, and then I would like to hear your view on how you think these two elements may function when now we have some experiences that show that product safety in Europe in a way functions as a way as a preemptive measure for avoiding exposed liability. Thank you.
Mm-hmm. Let me start with your second point. This is also my reading of the current regulatory strategy, that the European Commission strongly builds its regulatory strategy on product safety, this let's say stands and falls, I would say, with the effectiveness of enforcement. This then has institutional aspects, funding of institutions, cooperation between institutions, even such technical aspects. Think of this new requirement under the proposal for the General Product Safety Regulation to regularly check the database of product alerts. What Amazon is saying in this context is, well, but if you look at this database, it's not standardized. Some of these alerts contain product numbers, some contain photos, some don't. So it's very difficult to, let's say, have an automatic check there. There are a lot of ramifications if you want to build consumer protection on product safety and on such preventive measures. And even if that works fairly well, there will be some cases where unsafe products make their way to the consumers and produce damage. And I think for these cases, there needs to be some sort of liability regime for the compensation side. Whether product liability, and I think that then relates to the first part of your question, or your first question, whether strengthening product liability for online marketplaces in Europe really adds a meaningful incentive for platforms very much depends, again, on the enforcement, on the practical enforcement. If procedural law is the barrier, if the updated product liability rules are not applied in courts because the financial risk for consumers to file a product liability claim is too high, then it will not be effective. So it's the, let's say, the entire setup, the institutional setup, the procedural setup, not just the substantive rules here.
Thank you.
Thank you. Now I think that the next intervener is Dr. Kiara Angelini from the University of Trento, but I'm not sure whether I interpreted her message correctly. No, it's a misinterpretation.
No, I think that there was a mistake. I'm just listening this really interesting seminar. I've not questioned for the moment.
Sorry, Kiara, but the mistake is mine that your chat message I read it in, I misinterpreted it. All right, then the floor is open again for your questions and comments. You may either raise your electronic hand or post a chat message to everyone. And well, if nobody intervenes, then if I may abuse of my function of chair, then of course I have a comment, perhaps more a side comment than a question. It was by coincidence that yesterday night I had a long chat with an old friend of mine from the university study in Trieste, and she became a small entrepreneur and she has 3 small businesses. And she, my question, how are your businesses? And her answer was so clear. Well, small and smallest businesses are really killed by EU regulation on product safety, product liability, consumer protection, standards, diligence standards, because of the lobby, not only the lobby of the large enterprises, but now the new lobby is the lobby of the medium enterprises in Europe. And the medium enterprises use the proposals, the regulation, the proposal for regulations directive, and so forth, use as a mean of cutting out of the market the startups and the smallest enterprises. I found this very shocking, but your presentation definitely confirms that enterprises backing a proposal or even proposing something that might have as a first objective limiting competition, especially by newcomers. So what do you think, Christoph? Do you have any other insights or comments on this point?
I think let's say the asymmetric burden that regulation poses on bigger, medium, and smaller enterprises is indeed a serious challenge. And the Digital Services Act responds to this with this approach of asymmetric regulation of, let's say, different levels of due diligence obligations depending on the size of an intermediary or the type of business. For these due diligence obligations, I think that's a reasonable approach. But when it comes to consumer protection through liability rules, an asymmetric approach would be something really new. So far, consumers benefit from the same liability rules, the same protections through liability rules, regardless of whether you buy from a small seller or from a big multinational company. If you would start introducing, let's say, a de minimis rule or something like this, some type of asymmetric rule in the field of product liability, for example, that would really change the regulatory approach we have so far in the field of consumer protection. And that could also mean, all other things being equal, that smaller online marketplaces where consumers do not benefit from product liability could offer lower prices, which could then mean that financially more vulnerable consumers are shifting towards these smaller marketplaces where they don't, where they are not protected by product liability rules. So there might be a distributive effect here. So it's really, I do not envy the legislator about the difficult job of getting the liability regime right here. Yeah.
Thank you very much, Christoph. And now, do I see correctly that Mireia has a second question?
No.
No? Okay, because your hand is still raised.
I have tons of questions, but I think that would be a little bit abusive. So no, thank you. For now, I need to think more.
Okay, and then it's my pleasure to pass the floor on to Dr. Evert Neppelenbroek from the University of Groningen. Evert, the floor is yours.
Hello, I'd like to thank Professor Busch for this wonderful presentation. It was excellent and very clear and very convincing as far as I'm concerned. At a glance, I saw on one of your slides that a new product liability rule, I believe, was set up under an article which mentioned the circular economy. And I wondered about that. Can you explain what the connection is between this rule and instead of a linear economy, the circular economy?
I must confess that I don't see exactly which slide you're referring to. Maybe the one about the inception impact assessment for the review of the product liability directive. I would assume that circular economy aspects are also considered in this proposal. But I must say I'm not actually aware of a link between product liability for online marketplaces and aspects of circular economy in this proposal. Maybe that's more about, because this review of the product liability directive is of course a much bigger legislative dossier. It's about liability for autonomous systems. That's the much bigger and more prominent part of it. As you have seen, the online marketplace part is only 2 sentences in this proposal. I'm sure there are also circular economy aspects in there, but I must confess I haven't looked deeply into that. But I will do so because that might be
okay. Well, it's just at a glance, because it went very quickly. I thought, well, maybe there might be an interesting connection between it, because of course the classic product liability rules are based upon a very linear economy going from a producer to consumer. And well, it might be interesting to connect those two dots in a way. But okay, thank you.
Thank you for raising this point. I will look again into the proposal and try to find out. Yeah.
Okay, thank you.
Great. And now I see a question or comment by Benedict Schmitz, also from our University of Groningen. Large retailers often, yeah, Benedict, perhaps you would like to speak, or?
Yeah, sure. Thank you very much for the presentation. Yeah. It was, again, more a comment to the answer to Aurelia's comment. That, okay, maybe we could introduce some form of de minimis for smaller retailers. And you said already earlier that technically speaking, this could lead to lower prices, but when we look at the prices at the moment, where Amazon, for example, has the cheaper prices already, then the smaller retailers might reduce the price to the same as Amazon has, but at the same time, Amazon then is obliged to protect the consumer a lot better. So why then would the consumer choose for a smaller business? So it's very complicated, definitely. Yeah.
Actually, what I didn't mention, and this is closely related to what you have said, what I didn't mention, one of the very latest developments of this story is that in August, Amazon announced that they would actually pay up to $1,000 for product liability claims without really looking into the matter. And in some cases, they would pay even more without accepting any legal liability, of course. They would start, how did they call it, a sort of insurance intermediation scheme, helping third-party liability, third-party vendors to find insurance coverage. So they are trying to move forward with some consumer-friendly elements. But they, in my view, this is rather a strategic move to let's say, stop the discussion about mandatory rules on marketplace liability. And as you said, Amazon can afford to be a very consumer-friendly actor for consumers. Amazon is actually a very comfortable place, unless serious cases like these product liability cases arise. Yeah.
Thank you very much. I'm now looking at all participants. I don't see any further hands up. And yeah, given the time, I think that's a perfect timing to close this seminar and to thank warmly all participants and especially our speaker, Professor Christoph Busch. Thanks a lot. Thanks everybody, and hope to see you soon at the next seminar next month.
Thank you very much. Thank you.
Thank you. Bye.
Thank you.